Number 174, Newman versus RCPI Landmark Properties, LLC.
Hi, Judge. I'd like to reserve 2 minutes of my time for rebuttal, please.
You may, sir.
Thank you. This court granted leave to appeal from an order of the Appellate Division, First Department, that dismissed my client's case as a matter of law. The trial court or the lower court observed that in no way can this be a matter of law in terms of this particular case. Mr. Newman is that the position of Mr. Newman is that these crates were positioned in such a way that two were together on the bottom, followed by one above them between those, and it sort of looked like steps to him. He was followed his...
Reasonable, Counselor, is it reasonable for him to have followed his colleague down those steps when there was at least one other way he knew of that would not require him to do that, and that is to go back the way he came?
Absolutely wrong. He didn't know of the other way.
As I understand it, the record shows he had maybe been there once before. They walked through the sub-basement, they got to the platform, they could have walked back exactly the way they got there.
He was never there once before. The record...
Even if he wasn't, they didn't get there by climbing up the crates, right? That's not how they got to the platform, correct?
That was his first time.
No,
at the
he got
platform.
there somehow. He was on the platform, right?
He got to the platform.
How did he get there?
He got there from the building.
From the building. Why couldn't he go back through the building?
Because he was going to another part of the building down below. That he was going to another area in the building. So he's going to another area in the building, and this appears to him to be a logical place to go down. It is stacked neatly.
But it could be unreasonable to take that risk for convenience purposes.
Well, not as a matter of law, Your Honor. It's not unreasonable as a matter of law. This isn't a situation where the Appellate Division talks about someone jumping off a roof or someone jumping off an elevator that's stuck between floors.
But if he jumped off the dock, didn't go through these little, these crates, would that have been unreasonable, even though it might be more convenient?
No, it wouldn't be unreasonable, just like the cases we cite in the Appellate Division where it says it wasn't unreasonable for someone to be on a ladder, and underneath the ladder there was a defective floor, and the court held
So
that
basically,
it was a
counsel,
question
you
of
would
fact for the
like
jury.
your client to go before a jury, and the jury would determine whether it would be unreasonable or not for him to do that. And would the jury be able to find that he was 100% liable for his own injuries, or?
Oh, sure, the jury can find him 90%. I don't think in this particular case the jury would even find him negligent, but that's for a trial jury.
Can I take a step back? We're arguing kind of the sole proximate cause prong of the of liability, but they brought their motion as an affirmative defense under culpable conduct. So we're talking comparative negligence, which means that versus negligence, then there's proximate cause. And so let's start with the negligence. What do you say that the landowner, how was the landowner negligent here? What did they do? Let me just frame that question for you so you can answer it. They didn't put the crates there. There was a ladder there, but apparently it wasn't visible because of the way a truck was parked. But they did provide a means of egress. Let me finish. And so whether there were two or one is, for my purposes, irrelevant. So based on that, my question is, before I even get to proximate cause and whether there's sole proximate cause, is I want to know how you think, because you're really the one who could tell us. How are they negligent?
Well, in the record, there's an engineering expert, Stanley Fine, and the engineering expert says that the loading dock did not possess the proper form of egress. It was a violation of the building code, and he concludes.
So you're saying the negligence was a violation of a statute?
Violation of a statute and violation of the common law. He says, in conclusion, and speaking in general terms, the subject wall-mounted ladder was not an adequate means. He even says that the wall ladder was an adequate means, but that's besides the point from the loading platform, and it was not available at the time of the incident. A set of steps with proper handrails or wall guards should have been provided. accessing the vertical ladder was unsafe and did not provide.
Can you tell me this? Does he say what specific statute was violated?
Yes, he says a building code, the building code 28-301.1.
And this building was not
This is
subject to
the-
some exception or grandparented in because it was built some
No,
time
it's
before that
Rockefeller
building?
Center, which is like pristine in terms of security and in terms of
Yeah,
keeping...
but that doesn't, I mean, Rockefeller Center wasn't built like 20 years ago or whenever, I mean, what building code is he saying was violated?
He cites these, he cites the, in the record, he cites the building code that was in existence at, at the time. He cites the predecessor to this particular section. He also cites, a custom and practice in terms of this not being a proper. You have to understand that there were six or seven loading docks in Rockefeller Center. All the other loading docks had stairs or ramps. This was the only loading dock that didn't have stairs or ramps, and those stairs or ramps were visible. So when you would get to the loading dock, you could see them.
Did he look for a ladder? Did he
No,
ever
when he
look?
got there, he saw the crates. This particular loading dock was 14 feet wide. There were two trucks there. I'm assuming they were straight trucks, which are like 8 feet wide. So even if there was a ladder, one of the trucks had to be against the wall. He couldn't even climb down the
So
ladder.
your position is that it could be reasonable for someone in his position to go down and use those crates without even looking around to see if there was any other way down. Is that your position? That a jury could find that to be a reasonable thing to do?
Yes, Your Honor.
When, as you say, for every other dock, there's another way down.
There is steps, actual steps, and there are also ramps. So there are ramps. This is the only dock in Rockefeller Center that doesn't have steps or ramps.
This
all right?
is outside, right, counsel? Is
No,
this-
it's inside. In other words, when you come down 50th Street, you would come into the, I guess it would be the loading dock area, and you come down a ramp, and people from Tishman would actually park their cars down there, because they obviously own the building or maintain the building, and then there would be deliveries made, and these were milk crates. So we all know that...
There was a
milk is-
ladder
Yes,
attached
yes.
to the
Who's-
loading dock, correct? There was a ladder attached to the,
No, the ladder was on the wall, Judge. The ladder, in other words, let's assume this is a loading dock, and he's going to go down the steps. There's a truck to his left, and then there's a ladder on the wall that's hidden by the truck. And it's his first time there, so he doesn't know the ladder is there.
what's the purpose of that ladder?
We don't know. It could have been a fire ladder, it could have been a ladder going up to the ceiling. No one testified that the purpose of that ladder was to get off the loading dock. There's nothing in the record with respect to that. So the only way to get off the loading dock was using these crates. And they were milk crates.
The
And
thing
this
that jumps
accident-
out at me is, whose crates were they?
Well, we don't know whose crates there are, but we do know from the record that restaurants would deliver milk.
That's why, the reason I ask you that is because that's why I asked you the negligence question. It seems to me that the building owner did not put the crates there. They didn't create the negligence. So the only way you get the building owner, I think, at all is if there's some defect in design. And the efficacy of the ladder, okay, but I don't know if that gets you over that. So that's why I asked the question.
Well, Judge, Mr. Hagan, who was a safety officer, who testified in the deposition, said that there was a video, and those crates were there for at least a half an hour. He saw them in the video for half an hour. The video for the whole day, they destroyed. So these crates weren't just willy-nilly there for one purpose. They were there at least a half an hour before. They were probably there from early on in the morning, because milk is delivered early on in the morning. This accident happens at 10 o'clock. So they acquiesced in allowing these crates to be the only way onto and off of the loading dock. So they don't have to have, it couldn't be their crates, but they acquiesced in the idea that this is the only way to get on and off. And his partner had been there before and used the crates before. So it wasn't like the first time they were there. And they actually have a central control that has the video where they can see from central control what's going on in the loading dock, because
Also,
when the accident happens...
Are you saying, counsel, that his partner of that day had used those same crates on another day?
Yes, he has been there
Descend the loading
before.
dock?
He was the one leading him through because he had known this is the way to get off the loading dock. He didn't know any other way. He didn't know about any ladder on the wall that was not accessible because these are trucks coming in and out making deliveries to the various restaurants.
Thank you, counsel.
Oh, sorry. No, it's fine.
May it please the Court, Glenn Kaminsky with the firm of Amity Demers McManus. I'm counsel for the defendant respondents in this matter.
Can you go to the negligence question? You said that there was a building code violation. Want to address that?
The building code violations that the expert, Mr. Fine, refers to is about ingress and egress. They're not applicable to this loading dock in any way. This is not, it's in our brief that the position of Mr. Fine, who we see all the time in these cases, is he's citing a provision of the building code which talks about entering and leaving the building and what is required of staircases for entrance and exit of the building, not anything to do with a loading dock. It's simply a red herring and inapplicable in any way. So the answer to your question is, there is no negligence for the owner.
So we don't really need to, if there is no negligence, this court would not need to address the applicability of a sole proximate cause because there was no negligence in the first instance. Is that correct?
That is true. Yeah, if this court finds there's no negligence, which I think they easily could, we're talking about 3 milk crates, then you wouldn't
Well,
have to
except the
address
milk crates were there, and you were on notice of them, apparently.
Well, I have to take exception to counsel's position. Mr. Rinaldi never testified in this case. There is no statement that he had been there before and had used those milk crates before. But we do know that the plaintiff himself had been at this location about a month prior. I believe it's 164 on the record. I'm sorry, 143 of the record. He had been there before, and he turned around and went back the way he came, because that was the safe way.
Is there something to be said, following up on what Judge Fahey was asking, that you don't disagree that it's your burden in the first instance to establish your entitlement to judgment as a matter of law under 3212?
I think that's absolutely true. I'd love to fight that, but I don't think I can.
Did you establish that by saying we were not negligent?
I think we established, yes, I think we established it by
testified?
the facts of the case.
Well, that's very general. Who said we are not negligent because?
Well, I don't know that anyone ever says that, but what we
Right.
did say is presented the facts that he...
What you said, as I understand it, was whether we're negligent or not, there's only one negligence that counts in this, and that's his. That's
true.
Now, is that the law in the state of New York? I get it, as counsel's pointing out, where a jury can tell you that, but it seems, and in 240s, it seemed like we're, 240s accreting into common law negligence here. Am I misreading the record?
Well, no, the labor law really has nothing to do with this case.
Well, it's because of the phrase that's being used, sole proximate cause.
Sole proximate cause, but...
Take a step back for a second. Sole proximate cause is a response to the minimal requirements for holding a defendant in under labor law, subsection 1. If we assume that negligence is negligence plus proximate cause, and if a defendant can be held in under labor law with 1% negligence, then the sole proximate cause defense develops. A company, a construction site doesn't provide a ladder, but the plaintiff comes to work drunk. So the proximate cause of his injuries is not the non-provision of a ladder, but is instead the sole proximate cause of his injuries is the fact that he was climbing on whatever was provided to him, and he had drank a six-pack before he came to work. That's where the sole proximate cause is a substantial factor of defense comes into enough. What we're talking here is culpable conduct, Section 1411 of the CPLR, comparative negligence, and that's why Judge Piggott's question really directs us in the right place, and that's why I was asking about the negligence question, because I'm trying to figure, in the first instance, you argued in your briefs, but how do you argue on negligence? Was there a duty? Apparently there's a duty to provide ingress and egress, no one's denying that, so how did you fulfill it?
Okay. Again, this is not an ingress and egress matter because he's not entering or leaving
Up
the
and down
building.
the ladder.
He's going up
Okay.
and down the ladder. So how did we fulfill it? One, there is in fact a ladder. Okay. Two, He could have turned around and came the way he came, the way he did it a month
So
before.
your argument is he had two ways of getting up and down.
Oh, no, there's a third way.
Oh, okay.
He could also have, as testified by Mr. Hagan, he could have gone around to use one of the ramps that were available on the other 6 or 7, I believe 5 or 6, excuse me,
Aren't
other
those
loading
questions of
docks.
fact?
I'm sorry?
Aren't those questions of fact having to do with what the person's doing at the time?
Not at
Yeah.
all.
Well, if you're unloading a particular truck, let's say, and somebody says, well, you could have gone 3 bays down, and there's steps down there, well, that's not within the contemplation of the worker at the time that he or she is doing the job. So it's a question of fact as to whether that makes sense, that a jury would say, no, they did not have to go 3 bays down to get, to get off.
I think there's just a fundamental issue here, that this guy's job was done before he even got on the loading dock.
So-
Okay, he was there to
Well, that
look at
doesn't
the
make it-
storage room. That
Pardon
he
me?
never.
Pardon me?
He was there to look at storage rooms
Right.
that were behind the dock, And then he testified, we were going back to the 59th floor, which is the floor he came from. So he was done. Essentially, this is all detour and frolic. He didn't need to do any of this,
That's not
Those
your
are all
defense.
factual questions.
you know?
Yeah,
But the
yeah.
important thing is...
That wasn't your defense.
He sees...
You did not say he was on a frolic of his own.
No, but I'm just
Well, then
saying...
why are you arguing it now?
Because it's...
There are things in this record that we ought to get to know. All right.
The important thing is this. It's unreasonable to walk to the end of a loading dock, see something you identify, you know, are black milk crates that are stacked side by side with one in the middle. They're not even stacked like they would be, milk crates interconnect
But does
in
it
order to
matter,
be.
counsel, that his partner went down on those same milk crates and nothing happened? He wasn't the first one to use the milk crates.
No, it doesn't. It does not. You know,
Why?
this appeal comes from the First Department, but I was born and raised in Niagara Falls. And my mom would tell me all the time, if your friends jump off the Grand Island Bridge, are you going to
Careful,
jump off the
careful.
Grand Island Bridge?
But,
Because if they do, and I follow them, that's my fault.
but does the plaintiff's conduct have to be unforeseeable in order for it to be the sole proximate cause?
The law is unnecessary, unforeseeable, and it is. It's just like all these cases with the buckets that people turn upside down.
How is it unforeseeable that he would descend using those crates?
How is it unforeseeable? We have crates there. All right. But what if there was a folding chair? Would that be okay? That he can use that? I mean,
Well, I
they're
guess the
crates,
question
they're not what they're
is,
there for.
Can we decide that as a matter of law? That to
Absolutely,
me is-
absolutely. And the cases allow...
Is it because you're saying
about general-
it's inherently dangerous, it's obvious?
It's an unreasonable, dangerous act he took unilaterally. The only reason he fell is because he did this, and he did it himself for no reason other than he didn't turn around and go the way he came, the way he did it a month before.
And it doesn't matter that the crates were there for at least a half an hour, according to the video that was
No.
taken by your own...
It's a loading dock, you know, the materials are there at loading docks, you know, but because there's material stacked at a loading dock is not an invitation for someone to take an unreasonably dangerous act and step on something
Instead of
because...
milk crates, if they were cinder blocks that were pretty much more substantial, do you think that would have been...
I
made a
do not
difference?
think that you should
More
look
like
at something
steps.
stacked at a loading dock and say, boy, you know what, that's my way to get down.
Isn't his argument stronger because the ladder is covered? The ladder was exposed and obvious. Wouldn't that be a different kind of case? But it's covered by a truck, and as you said, it's a loading dock.
Yeah.
These things happen.
I would say it doesn't really, does it make it stronger? No, you know, because he never looked. You know, the First Department tells you, he didn't look.
So if he
comes
had
to the-
testified and said, well, I looked around, there was nothing else.
That would have made a stronger case, because maybe he made a choice different, but he still always had an option.
Aren't those all questions for the jury? Aren't those
No,
all factual
not
questions
at
at
all,
that
because
point?
No, because there's nothing dangerous about 3 milk crates in a loading dock, except if someone trips over them or backs into them, like Mr. Hagan said, that's a dangerous condition. is not dangerous because he used them for something completely unforeseeable, for some use that they're not supposed to be used for.
Thank you, counsel.
Thank you.
Counsel?
Why do I feel that, having heard my adversary's argument, that I feel I'm at the trial court, and he summed up for the defendant, and now it's my turn to sum up for the plaintiff? These are definitely issues of fact for the jury. He did look in that direction. He didn't see any ladder, Judge, because the truck was blocking it. So whether he was reasonable or unreasonable is a question of fact for the jury. They never really argued strenuously, if they argued at all, that they were free from negligence in this
The appellate
particular
division
case.
found here he didn't look.
Excuse me,
right?
Judge?
The appellate division decision says he did not look. Are we bound by that?
Well, if you look at the record, his transcript says in the record that he looked in that direction, and he saw it. So,
I guess my fundamental issue here, though, is there's no argument that he thinks the milk crates are the way to get down off of this platform. I mean, they're there, they're obviously temporarily there. If it's a half hour, if it's 2 hours, if they were delivered first thing in the morning. That's not the way the ramp is designed, that this loading dock is designed. No one thinks, to get off this loading ramp, I step onto some milk crate.
Well, Judge, then you and I differ, Judge. If I were approaching the loading dock and I looked around and there was no other way to get down, and I wanted to
say,
get
where are
down
the
from
milk
loading-
crates?
maybe I'm unreasonable. I would have taken,
But there is another way, as Judge Stein said at the beginning.
I would have taken
Counsel,
it.
counsel, but there is...
Maybe I'm more
counsel,
unreasonable.
Counsel, there is another way. You can retrace your steps, as Judge Stein pointed out when we started this oral argument.
But-
I know you argue that that is inconvenient, but there is another way. It's not that he's trapped.
It was never argued that he was going back, that he could have gone back. He was going forward for some reason.
It's obvious that he can retrace, right? Because that's how he got to the dock.
Judge, if you go back, if you go to Rockefeller Center, it goes from 46th Street to 50th Street. It goes from 5th Avenue to 6th Avenue. It takes so much time to walk, as he says, to walk to another area. You're walking blocks. I have an
When you
I have
walk
an
down
office
blocks, you're not
on-
worried you're going
on
to
5th
fall
Avenue
over.
and
You're
8th.
not worried you're going to fall over milk cartons.
But it was such an obvious thing. It's there. The way it was set up, judges, here's the loading dock. Here, it was set up the way it was even. It was even, the crate was even with the loading dock. It's a question of fact for the jury. We should be allowed to try this case in Supreme Court, New York County. Thank you for your time. Thank you.
Thank you, sir.